Welcome to the Lady Landlords podcast, where we empower women to gain financial independence through real estate investing. I'm your host, Becky Nova, founder of Lady Landlords. If you're ready to buy, manage, and grow your real estate portfolio, then let's get started. Are you worried about not being able to collect on back rent or damages that have been done to your property as a landlord? If so, this episode of the Lady Landlords podcast is just for you. Hi, everyone. My name is Becky Nova. I'm the founder of Lady Landlords. And today I wanted to talk about something that is really just a reality within rental properties. And that is the possibility of lawsuits and going to court. Now, why are we talking about this topic today? If you're in the Lady Landlords Facebook group, which I hope you all are by now, one of the topics that we've been discussing over this past week was some recent court cases that I myself have actually been in. So since my husband and I have become landlords back in 2018, we've actually now gone through 5 different court cases. Yes, not 1, not 2, but actually 5 different small claims cases that we've had before. And I want to make sure that we kind of talk about these, because what's important to know is that it's not always just a situation between a tenant and a landlord that could possibly get you into court. So I want to share a little bit about some of the court cases that we have gone through, just to give you some examples of some situations that you also might see as a property owner and then also as a landlord. And then I can share a couple of tips with you about what you can do to make sure that you can also be successful in your small claims cases. And then lastly, the most important thing I want to make sure that we can address, and the biggest question that we always have about this topic, is how to actually then collect our money. That tends to be the hardest part. So stick with me and I will make sure to answer your questions about that. So as I said, 5 small claims cases. There actually could have been a 6th in here, but fortunately we were able to kind of settle with those 5. And what's great is that Emilio and I have actually been successful in winning every single case in small claims that we've been to. So let me share a little bit about what these cases were about. The first case, ironically enough, the first time I had to go to court, being a landlord, the first time we had to deal with the situation was actually right after the closing of the first duplex that we bought. And unfortunately, / oddly enough, the person that our case was against was our own attorney. Unfortunately, throughout the closing, our attorney really, in our opinion, did not act in our best interest, and it ended up costing us money, and there were just negligent acts. So because of that situation, we did feel that it was appropriate to go to court. This was actually something I had to speak to another lawyer about, to even see what my own rights were in this situation. It was very confusing being in that situation when you think that the person that's there to protect you is actually not really working in your best interest. That's a very hard pill to swallow, especially when you're buying properties and really making these expensive purchases that can affect somebody's life. So we really felt that it was the right thing for us to be able to do in that particular situation. So that was case number 1. The almost case that actually happened was a title company. So as you know, or should know, title companies are responsible for making sure that the person actually selling the property is the person that actually owns the property. And they're also responsible for checking if there's any types of liens or any type of kind of outstanding bills that are occurring to sell that property. And we actually had a title company that missed a $7,000 bill that unfortunately got placed then on as a lien on one of the properties that I own. Clearly, I was not going to accept that. Luckily, my new fantastic, amazing attorney, Jay Zimner, who, if you have not listened to Jay's episode here on the Lady Landlords podcast, please do make sure to go back and get some great legal advice from Jay in that episode. But we were really able to use our attorney to help make sure that we were able to get all the money that we were owed from this title company, really missing what that bill looked like. So we were able to avoid a court case there. But so we got through 1 and that kind of 1.5 year. The second case that actually came up is an interesting situation. So our first duplex that we bought is a row townhouse, right? So think back to all those different types of houses that you probably would think of in a large city, where we all kind of share the same walls. We all share the same roof. Our front walkways are all attached. So since those buildings are all connected, sometimes if there is an issue going on at one of the properties, it might kind of run across to some of the other townhouses. And that was actually what happened in the situation. Our tenants in the upstairs apartment of this property had reported that there was a leak coming in. Well, when we bought the property, we'd actually redone the roof. So we were surprised by that, but okay, problems happen. We got our contractors back out and were able to take a look at it. What we realized and were advised by our contractors and our roofers was actually that the leak in the water that was running into the property was actually coming from an issue with the roof on the property next door. So we went and were able to kind of talk to our neighbor who we had and still have a great relationship with, and kind of explained, hey, this is really kind of part of the issue. We got our roofer together with his roofer and really went over some of the work that needed to be done. Great. We all understood where it kind of came from, what situation we needed to take next, and what steps we needed to take next in order to fix this problem. At a point, though, there was still that leak coming into our property. It then started to get a little uncomfortable between us and the neighbor of saying, well, who's really responsible for fixing certain things? So what we actually decided to do was to pay to fix the problem. And then our neighbor and I both agreed that the best solution to keep that amicable relationship would be to go to court and have a judge tell us who really should be the right party to be responsible. It actually worked out fantastic because it took away then one of us feeling like we were pushing the other, or really kind of having that negative relationship of being like, oh, well, this person should have paid. I think they owe me. And then the other person saying, well, I think they owe me. It was really kind of nice that we were both able to go to small claims court and just say, hey, here's the situation. I feel this way. The other homeowner felt this way, and really let it up to the judge to decide really which way that should go. So it really kept our relationship intact as neighbors, which was absolutely fantastic to say, let somebody else tell us what really is the right solution in this case. So we were able to do that. And the judge actually sided with my husband and myself on that now being case number 2. So those, once again, now I've gone through 2 cases and they actually have nothing to do with tenants or back rent or damage or anything like that. But case number 3 is also going to fit into that same category. And case number 3 was actually the first time that we were sued, being landlords and property owners. What that lawsuit actually came from was the seller of a quadplex that my husband and I bought. So why did we get sued? We ended up getting sued, and this is something that I really like to make sure that people also understand. It happens very often when you are buying or selling a house that there might be money that is held back in escrow. For example, if you go to that walkthrough and there are an item that maybe is not necessarily done, a possibility would be to keep money in escrow, which means that it's held in a separate account. It's not given to you as the buyer. It's not given to them as the seller. And that money sits in that separate account until those actions take place. So for example, let's say you go to the walkthrough and there is a leak under the kitchen sink, right? Well, you don't want to just close having that leak there that now is going to be your problem when it's really something that was supposed to be taken care of before you close. So an option would be to have money kept in escrow. So that way the seller will be able to finish what that project is. Then if the seller does not fulfill their obligations of completing that item, then instead of them getting that money, then that would actually come back to you as the buyer. So this is a handy tool of keeping money in escrow for situations. And there's a ton of different situations, too many to even really name on this podcast here, of why there could be money that's kept in escrow. But in our situation, money was actually kept in escrow because the sellers still had to do a lot of cleanup of the property. They were hoarders that had lived in this property for decades, and they just needed more time to be able to kind of move things along and really remove their items from that property. They also, we had back rented to them. So it made sense to allow them the time to continue to move their possessions off that property while they were actually still living in one of the units. But we set a nice clear structure of what needed to be done and by which time frames, and we had different payouts for the amount of escrow that we had held back. And there were some time points that we agreed that they completed those items during that time, and then therefore that money from escrow did get sent to the seller. But there were other time points that we felt that the seller did not meet their obligations, and we felt that actually that money in escrow was owed to us. Here's where the problem is. When the two parties, when your seller and buyer do not agree on who actually gets that escrow, the only person that can decide is the same as what I was talking about in case number 2, is actually then a judge. So it's kind of like the old Seinfeld joke about submarines, where kind of both people have to be able to turn their keys. So money can be released from escrow if both the buyer and the seller agree that the seller gets the money. And the money can be released from escrow if both the buyer and the seller agree that now the buyer would get that money. But if the two parties disagree, there now has to be a neutral party that would agree, that would make the decision on who would be the right party to get that money in escrow. And that's what happened in this situation. The seller still felt that they were deserving of that money. We felt that we were. So they sued us for the money in escrow, and actually we countersued as we felt that that money was something that we deserved. So this was actually probably the most involved court case that we've ever been in. It was something that it took us quite some time to go through. Reason for that, we not only had to go through the actual court case, and we actually went through a full trial with that, which is a very unique situation if you have never gone through that. But going through that whole court case, it actually took multiple days in court that we had to go to. Then after the court case, we won, woohoo. We finally got that judgment in the mail months after the trial finally ended. But the plaintiff, the seller in this case, actually had the option to still appeal that decision. And that was actually what he chose to do. So now our case ended up moving forward into an appellate court, which means then that case had to either be heard again, or they now had to have another judge review the entire transcripts of that case and then make a decision at that point. At that point, we actually did not have to go through a trial all over again, but the seller had to write a very clear explanation of why they disagreed with the judge and the judge's decision. And then I had to respond back to that. The seller wrote over 100-page response to why he felt that the judgment should be overturned. And that was something that I had to respond back to. So not only did it take quite a bit of time, but it was something that then really extended the amount of time that it was for us to be able to then collect on that. It was then months later when that appellate court made the decision. My husband and I, once again, still ended up winning the case in the end at that point as well, which was fantastic. But it then took quite some time for us to be able to get that money out of escrow. But with that judgment, it did make it a little bit easier to be able to do so. Now, that was case number 3. Now moving into cases number 4 and 5, this is where the situation changes when it comes into the tenant situations that we had had. We had a tenant back that had actually broke his lease early and wanted to leave, oddly enough, in March of 2020. At that point in time, he made it very clear that he would be breaking his lease. He wrote even in his email, being very clear about when he would be paying us the remainder of the money that he owed us and to break that lease. And then he moved out and he left us a ton of damage, and he left us also footing the bill. Well, we were able to still keep his security deposit for some of those damages, but he still owed us that extra money. So we did have to go to court in order to recover those funds. And I will talk about how that happened in a minute. Then now case number 5 ended up being another situation with a tenant that was, I decided that she was going to leave her month-to-month lease, but unfortunately did not follow the terms of that month-to-month lease and did not provide the proper notice needed. And therefore, we ended up in court again for that back rent. Very simple. It was very easy having that documentation, going to court and being able to get that judgment now. So those are the 5 court cases. And out of those 5, almost 6 cases, only 2 of them were actually with tenants. But so I wanted to make sure to kind of share with you that there are other situations of why you can end up being in small claims or how you can end up being in court. All those situations I just named are small claims. They were all amounts that were $5,000 or less. So they were all things that I was able to represent myself in these situations instead of actually needing to pay for an attorney. You are absolutely able to pay an attorney, but usually in small claims, that's just not necessarily something that's done because there's not so much money that you're really looking to recover, that the cost of hiring an attorney usually ends up eating up more than the amount of money that you would be owed. So here are some tips that I would like to share with you about what I did to make sure that we were winning these court cases. So first thing that always helps me out is I write out a very clear timeline of what happened and when it happened. So for example, the court case that I had last week about a tenant that had moved out and still owed us money, that was something that I wrote out a very clear timeline of when she signed the lease, when she moved in, when she last paid rent, all of those different dates. So that way, when I was speaking to the judge, I knew that I could be very clear and give correct information about what had actually happened. The second thing that I always do when I go to court is make sure to have all my documents and pictures ready to go. That might also include leases, text messages, emails that you had with the tenant, pictures of any type of damage, anything else that can really show as evidence and really prove your case is going to be incredibly important. Besides just using our words, it's it's so much easier in a court case to really prove what you're trying to say with evidence such as a documentation signed by both parties with a date, and then also showing pictures and also getting time-stamped pictures as well. You can clearly do that on your phone through text messages, but also it's really nice to sometimes be able to have timestamps on your pictures as well for your court cases. Last tip I'll give you about actually being in small claims is to really stick to the facts. Now, I get it. Court, not fun. By the time we get there, we're probably in a situation where we're very frustrated with the tenant. We feel that we're out money. We are unhappy with what's going on. And we probably feel some type of way about us now having to spend our time collecting money from somebody that we truly feel owes us. But I'm here to tell you that the judge does not care that you're unhappy. They do not care that you're frustrated. They do not care that you had to take off a day from work to go now to court. So do make sure to stick to the facts and share no more or no less information than really is pertinent to the case. Stick to the facts, keep it clean, keep it very simple, and really just repeat the facts for the judge so that way she or he can make their decision in your favor. Now, that gets us through our judgment. Now we got our judgment, great. You won your court case. No better feeling than that, except when you realize that now you have to collect that money. That is not always the easiest. Reasons for that is clearly in certain situations. One of the reasons we actually have to go to small claims is because someone feels that they do not owe us that money, which means that they're not going to necessarily make it very easy to collect that money. Sometimes, on the other hand, they really just do not have the money to be able to pay us. So what do we do in those situations? What I always start with is that idea of open communication. For example, that court case number 4 I shared with you with the tenant that moved out early and left us with a bunch of damage. I was able to just send him a message saying, hey, look, here's the judgment. You know, we won the court case. Let's work something out. What can you pay us? What time points can we kind of agree to on this? It always is a better idea to see if you could negotiate something straightforward and from the beginning, because you'll probably end up being able to save time and be able to recover a large amount of money if you can work out something with the other party that owes you money. So we started there. Luckily, in that situation, our tenant actually came back and said, thanks for sending me the judgment. You're right, I owe you the money. I will send you this amount on this date, and I will send you this amount on this date. And they actually did. That was fantastic. The reason for that is after they see that judgment, they do understand that there are other things that we can do going through collections agencies and some other unique scenarios that I'm going to talk about in a minute. But it's really nice when you can at least just start and see if there's anything that you can actually collect up front from that tenant when you get that judgment. Then when you have a judgment, if now your tenant or whoever the other party that you're pursuing is not getting back to you, does not want to pay up, you now have 2 options. First is to kind of go it and do it alone, do it yourself and be able to collect up that money. That can end up being very time consuming. That can also be something that is going to be a headache. And this is not something that we necessarily do on a daily basis. So it's going to be a little frustrating just navigating the system and making sure that you have the right paperwork and go through the right process to be able to get some of these options done. The other way to go, option two, is to actually go through a collections agency. So there are different ways that you can employ somebody to go through that process for you. Now, that clearly means then that out of that judgment that you earned, you will be having to pay some fees. Usually between a 30 to 50% of that judgment could end up going to that collection agency or an enforcement officer in these situations. But once again, 50% is still better than zero. So that's still an option to kind of take a look at. Even with an agency, though, it could really take quite a bit of time to be able to collect. And that's something that I feel like you have to remember with court cases. Justice does not move fast. So if you are going to go and do this alone and go through it on your own way, one of the most important things to do is once you get that judgment is to follow up with your local court and ask about the different options that you have to collect. A lot of those courts can actually help point you in the right direction to get the ball rolling. They can either point you in the direction of a collections agency or what's called an enforcement officer, which in that situation could be a somebody either on the police force or the sheriff's office that would actually be able to help make that negotiation for you. They also, in some situations, depending on your city and state, can also help you get a subpoena for your for the person that you won the judgment against assets. So that way you can see, do they own property? Do they have a car? What type of assets do they really have that you would be able to collect your judgment from? So that's something that you can just really start by speaking to the court officer about and just seeing if you can really kind of get any type of leads that way. Now, when we do our tenant screening and have tenants move in, part of our package to move in is getting a copy of a social security card and also a driver's license. We do that also not only for credit checks, but for the verification to ensure that the person filling out the application is the actual person moving into the property. It also does help us in these situations to have a social security number and also that driver's license number and state. The reason for that is because when now you were going and attacking these different assets that a person may have, there are some different ways to do that. One, with a social security number, you could possibly go through and garnish somebody's wages from the place that they work, where then they are actually not collecting that money directly, but where you would actually get a small portion of it every month until that judgment is paid off. Also, within using that social security number, there is the possibility where you could receive your judgment and the money's owed through somebody's tax return. So that's also another reason why it's important to collect that number. The driver's license ID number is interesting because there's also the possibility of going through the DMV. This is something where when monies are owed, that there is the possibility where you have somebody has an asset of a car that you would be able to either put a lien on, or sometimes the DMV can also put restrictions on that person's registration, driving abilities until they actually pay back that judgment. So once again, it really depends on the judgment itself, and your state, but these are definitely some options you want to look into to make sure that you've been able to collect. Also, another situation that could come up is if that person actually owns any type of property. Maybe it's not, they might have been a tenant, or once again, I mentioned multiple cases that I was in that did not include a tenant, but if the person that you won the judgment against does have any type of property, well, that's also something that you could be able to collect on or put a lien against. So there are still ways that you would be able to collect. Sometimes it could be very easy, just like in the situation that I shared with having communication with the tenant that was able and in the position to pay up. Other times, like I said, it took me about 2.5 years to be able to get money out of escrow that I was owed and to be able to get through all the different steps to collect there. It could take even much longer than that. So make sure that you do your best to avoid small claims cases or any type of court case when you really can from the beginning. But if not, do know that there are ways and channels to go through this. You just have to decide what is really worth your time. And if that money, or sometimes the principal might even be more important to you, is really worth the time commitment of following these things through. Also, once again, that's where it's a great option to be able to work with a collections agency to be able to collect. My recommendations for finding a collections agency would be to always start with your attorney, or once again, then going through the court system and seeing who people locally use. That way you can always get your referrals, which I am very big on, And that's something that would help you be able to collect from your tenant during a court case. So I hope you never end up in any of these situations or in court, but I would really like to help make sure that you are prepared if you are going to court and if you ever do end up in a situation like this. And I hope that sharing some of the cases that I personally have gone through have given you some ideas of situations to help make sure that you can avoid those in your own real estate investing journey. Thank you so much for joining me for today's episode of the Lady Landlords podcast. Please do make sure to subscribe if you're watching on YouTube or wherever you listen to your podcasts, so that way you do not miss our next episode. We release new episodes of the Lady Landlords podcast every single Tuesday. Thanks so much, and I will see you back in the Lady Landlords Facebook group. Thank you for listening to today's episode. If you're feeling stuck in your real estate journey, visit lady-landlords.com/roadmap to book a one-on-one workshop with me. I'll help you determine your next best strategy. Or you could subscribe to our newsletter for exclusive tips and offers. Invest with confidence. Become a lady landlord today.